Report of the Center-State Relations Inquiry Committee, 1971, Government of Tamil Nadu, Chapter 10, Public Services, All India Services. The committee, under the terms of reference, need not consider the state services, that is, the services which are under the rule-making control of the state government, nor need it consider the central services such as the customs, railways, etc. The services which bring the state government and the union into close contact are the All India services. The Constitution at its inception provided for only two All India services, namely the IAS and the IPS. These were in addition to the All India services in existence before the Constitution, the ICS and the IP. In addition to the ICS and IP, the Forest Service, the Service of Engineers, the Medical Service, Civil, the Educational Service, the Agricultural Service, and the Veterinary Service were constituted by the Secretary of State. The recruitment by the Secretary of State to the All India Services formed by him ceased in 1924 except for the ICS and the IP. Article 314 of the Constitution protects the conditions of service of the officers appointed by the Secretary of State. Clause 1 of Article 312 empowers Parliament by law to create new All India services if the Council of States has declared by resolution, supported by not less than two-thirds of the members present and voting, that it is not necessary or expedient in the national interest so to do. Parliament has enacted the All India Services Act 1951, Central Act 61 of 1951. That Act, as originally enacted, applies only to the state IAS and IPS. By Central Act 27 of 1963, the Act was amended to include the Indian Service of Engineers, Irrigation, Power, Buildings and Roads, the Indian Forest Service, and the Indian Medical and Health Service. Article 312 does not provide for consultation with state governments, much less for the consent of the states being secured before the Union makes any provision for the creation of an All India service or regarding the conditions of service of any All India service. The only requirement contained in the article is that the Council of States should pass the resolution referred to in the article, and once this is done, Parliament can unilaterally create an All India service. In the draft constitution, as settled in February 1948, there was no provision corresponding to Article 312. The Ministry of Home Affairs, in its letter addressed to the Constituent Assembly Secretariat on the 15th of October 1948, proposed the insertion of a provision which now figures as Article 312, then numbered as Article 282A. In the marginal note to the new article, the Home Ministry indicated that it was modelled on Article 226 of the draft Constitution. Article 226 of the draft Constitution now figures as Article 249. Sardar Vallabhbhai Patel, as Home Minister, in his letter dated the 27th of April 1948 to the Prime Minister dealing with the new provision, said that matters relating to recruitment, discipline, control, etc., had been settled at a conference of the Prime Ministers, that is, Chief Ministers of the then provinces, convened in 1946, and that details had been settled by correspondence with provincial governments. Sardar Patel stated that there could be no criticism because there was a remarkable unanimity between the views of the provincial governments and those of the central government. He added that any pricking of the conscience on the score of provincial autonomy or on the need for sustaining the prestige and powers of provincial ministers was out of place. It will thus be seen that, to start with, the rules relating to the IAS and the IPS were made in consultation with and with the concurrence of the provincial governments. As already stated, there is no constitutional requirement that the state governments should be consulted before any All India service is created. It's no doubt true that Section 3(1) of the Act of 1951 states that before rules regulating the recruitment of and the conditions of service of All India service personnel are made, the state governments should be consulted. Consultation does not imply the consent or concurrence of the authority consulted. In other words, it is the central government who are supreme in the field, and they can, according to law, brush aside the suggestions or comments of the state governments and insert provisions in the rules relating to all India services with which the state government may not agree. In fact, as indicated above, the 1951 Act was amended in 1963, clothing the central government with power to create several new All India services. Of these, only the Indian Forest Service has been constituted, although the Indian Medical and Health Service has been constituted from February 1969. Seven states have either decided not to participate or are reconsidering their earlier decision to participate in it. Again, although necessary provision has been included in the Act in relation to the Indian Service of Engineers, it has yet to come into existence. The Rajya Sabha had passed a resolution under Article 312(1) recommending the creation of the Indian Educational Service and the Indian Agricultural Service. But a large number of states having decided not to participate in the two services, no action is proposed to be taken to provide for the creation of the Educational Service and the Agricultural Service by amending the 1951 Act. Wide, The Hindu, dated the 15th of May 1970. The study team of the Administrative Reforms Commission has observed, quote, in a federal setup to have an all India service that serves the needs of the states but is controlled ultimately by the Union is an unusual feature. Unquote, page number 237, volume 1. The demand that the All India services, insofar as they come within the control of the federating units, should be subject to the ultimate authority of the unit itself, has been voiced even at the time of the framing of the 1935 Constitution Act. The following paragraph from the report of the Joint Parliamentary Committee explains the demand. Quote 296. We have found the problem of the future recruitment of the two principal administrative services in India, the Indian Civil Service and the Indian Police, among the most difficult of those with which we have had to deal. The appointing authority must necessarily control the main conditions of service, and if control remains with the Secretary of State, there will, to that extent, be a derogation from the powers over the officers who are working under it, which an autonomous provincial government might expect that the Crown should delegate to it. Such a derogation is inevitable in the case of officers recruited by the Secretary of State before the establishment of the new Constitution. But it was urged before us and has been again emphasized by the British India delegation in their joint memorandum that future recruitment by the Secretary of State of officers who serve a provincial government is incompatible with provincial autonomy, and that the All India services ought henceforth to be organized on a provincial basis and recruited and controlled exclusively by the provincial governments. Unquote. page 182 of Volume 1. It will be observed from the paragraph reproduced above that even as early as 1929 and 1930, enlightened opinion in what was then known as British India was in favor of vesting the ultimate control over the All India services in the unit. As regards the argument that the Council of States acts as the representative of the states, what this committee has stated in relation to Article 249 applies with equal force to Article 312 also. As pointed out in relation to Article 249, the Council of States is composed of representatives chosen in an indirect manner, and the states are represented in that House with reference to the population of the respective states. There is no answer to the argument that Article 312 and the Central Act of 1951, along with the rules made thereunder, violate the autonomy of the states. In other federal constitutions, there is no question of any service being common to the federal government and the regional governments. The two have their own respective services. It may be that the federal government may execute its programs and schemes through the agency of the regional governments and officers subordinate to the regional governments. So also the regional governments may take the help and advice of the federal officers and authorities. But the question of the federal government exercising control over officers serving the governments of the units does not arise in any other federation. In our country, the All India services have come to stay. This committee is not concerned with the advantages or disadvantages of the All India services, which have been dealt with in great detail by the study team of the Administrative Reforms Commission. The Commission has contented itself by inviting attention to its report on personal administration. Relevant extracts from its report on personal administration are given in Appendix 2 to its report on center state relationships. In short, the Administrative Reforms Commission has recommended that a specific functional field must be carved out for the IAS and that it should comprise land revenue administration, exercise of magisterial functions, and regulatory work in the states in fields other than those looked after by officers of other functional services. There have been strong criticism of the attitude of the Administrative Reforms Commission regarding All India services. See the two articles by two members of the IAS published in October-December 1969 issue of the Indian Journal of Public Administration. The same issue contains another interesting article which may be said to reflect the other viewpoint. The Union Home Ministry and the Secretaries Committee are reported to have rejected the recommendation of the Administrative Reforms Commission to restrict the field of the IAS to land revenue and magisterial functions, leaving the other items of work to be performed by other functional services. Wide the Hindu, dated the 6th July 1970. This committee has to examine as to how best the powers of the states as autonomous units could be safeguarded while at the same time retaining the All India services. The present method is to recruit the officers for the All India services through the Union Public Service Commission. Their conditions of service are regulated by the Union Government, of course, in consultation with the states. Under the rules framed under the 1951 Act, the ultimate authority rests only with the Union and the Union Public Service Commission. The only way by which the states could be effectively and purposefully associated in the scheme of All India services is to concede the demand put forth before the Joint Parliamentary Committee early in 1930 or so. As would be clear from the extract given above, the demand was that the All India services should be organized on a provincial, state basis, and that it should be recruited and controlled exclusively by the provincial or state governments. Recruitment through the Union Public Service Commission may be discontinued. This state recruits personnel to the state civil service, deputy collectors. Apparently, other states also must have similar services. In addition, the gazetted ranks in the state services, which form the main field of recruitment for promotion to the IAS, as distinct from direct recruitment through the Union Public Service Commission, are also filled by the state through direct recruitment with the help of the State Public Service Commission. It will be in consonance with the autonomy of the states and will improve the administrative ability to a large extent and add strength to the All India services if recruitment to the All India services is either by transfer of members of the gazetted service under the control of the state or by direct recruitment or by a combination of both these methods, if need be, by holding an examination confined to each state under the supervision of the Union Public Service Commission, if deemed necessary or expedient, with the adoption of the regional languages as the official languages by the various states, the selection of officers for manning the All India services by a distant central agency not familiar with local conditions is bound to create disharmony. Our suggestion may have to be worked out in greater detail. We have set out only the main principle which may be considered further. Our suggestion will have the advantage of securing representation for all the states in the All India services, and an officer before he gets into the All India service would have put in a sufficient length of service under the state government. We have already referred to the attempts to create new All India services and how the attempts had to be given up because of opposition from the states. There appears to be no justification for the constitution of any All India service which relates to subjects within the exclusive field of the state. It cannot be denied that there may be a feeling among the non Congress state governments that the All India service officers are the agents of the centre and may not carry out the policies of those states. We therefore suggest that Article 312 may be so redrafted as to omit the provision for the creation of any new All India service in future. With the adoption by several states of the regional languages as their official language, the question is as to which language should be the medium of examination for recruitment to the existing All India services, namely IAS and IPS. In the scheme suggested by us, the recruitment will be on a state-wise basis. Officers of these services are liable to be posted to other states also and to serve in the center. In our recommendations regarding the official language, we have suggested that the linked language between the center and the states and among the states themselves should be English. This committee feels that the better choice would be to continue English as the medium of examination for the All India services, although the recruitment may be on a state-wise basis. In any case, a good and sound knowledge of English should continue to be an essential qualification for entry into any All India service. While on this subject, this committee cannot refrain from commenting on the financial burden that is cast on the various states and other authorities and bodies subject to the control of the state government whenever the central government unilaterally enhances the salary, allowances, etc., of its employees. This sometimes prejudices the cordial relationship that should otherwise prevail between the Union and the states. One method would be for the central government to consult and have due regard to the views of the state governments before the centre increases the emoluments of its employees. This by itself may not go a long way. The best solution seems to be that the increase in emoluments of government employees, central and state, should, as far as possible, be uniform throughout the country, making allowances for local or special conditions. State Public Service Commission. Connected with the topic dealt with in this chapter, there is one provision in the Constitution which looks rather odd. It's Article 317. The members and chairman of the State Public Service Commission are appointed by the Governor. The strength of the State Service Commission and the conditions of service of the members of the Commission are regulated by the Governor. The Governor has also the power to suspend from office the chairman or any member of the State Service Commission in respect of whom a reference has been made to the Supreme Court for removing him from his office. But curiously enough, the actual power to remove the chairman or any member of a State Service Commission, whether on the ground of misbehavior or on the ground of insolvency, physical infirmity, etc., is vested in the President, which means the Union Cabinet. According to the Government of India Act 1935, the tenure of office of the members of the Provincial Public Service Commission was determined by regulations made by the Governor in his discretion, Section 265 2A. In the draft constitution, this provision was reproduced. Article 285 2A of the draft constitution empowered the governor in his discretion to make regulations determining the tenure of office of the members of the Service Commission. A conference of the chairman of all provincial public service commissions and the chairman and members of the Federal Public Service Commission was held in May 1948. One of the suggestions made at this conference was that the Constitution should provide for the removal of members of a Public Service Commission on the same ground and in the same manner as judges of the Supreme Court and High Court, and that accordingly such removal should only be made by an order of the President. At one stage, the Home Ministry expressed its opinion that it should be open to the Governor to remove a member of a Public Service Commission on 6 months' notice without being required to ask him to show cause against such action being taken. Dr. Ambedkar ultimately proposed, as a via media, that the member of a Public Service Commission may be removed by the President or by the Governor by warrant under his sign manual on the ground of misbehavior on a report made to that effect by the Supreme Court. But in the amendments placed before the Constituent Assembly in August 1949, it was simply provided that the President alone would be the authority competent to remove the chairman or member of even a state public service commission on the ground of proved misbehavior. In this state, there was a separate act passed by the local legislature establishing the Madras Service Commission. The act, passed in 1929, contained provisions regarding the composition and functions of the commission. The only commission in existence in the whole country at the time of the 1935 Constitution Act was the one in this state. In the Punjab, the legislation for setting up a public service commission had been passed, but the commission had not been established by then. Thus, even before a service commission was thought of for other states, this state had the proud privilege of having established a service commission by a local act. That act vested the power of removal of the chairman and members of the commission on the governor. The draft constitution also conferred power on the governor himself to order the removal of a member or chairman of the Public Service Commission. The requirement that the removal of the chairman or a member of the State Public Service Commission should, where such removal is on the ground of misbehavior, be only after a verdict to that effect is pronounced by the Supreme Court, preceded by an inquiry, may be replaced by the requirement that the verdict in this behalf should be that of the High Court, preceded of course by an inquiry. This will be in consonance with the self respect of the state and its autonomy. We recommend that the power to remove the chairman and the members of the State Public Service Commission should be vested in the governor of the state. The Tamil Nadu Public Service Commission has stated that it is not desirable to change the existing provision as found in Article 317(1), as it is a safeguard to preserve the impartiality and independence of the Public Service Commission. It has stated that the power is vested in the President and not in the central government. The President means and connotes only one authority, and that is the central government, that is, the Union Cabinet. As regards the impartiality and independence of the Service Commission, the state has as much interest in maintaining them as the Union. In fact, the state is more interested in the integrity and independence of the Commission than the distant centre. Further, the removal will, according to our suggestion, be preceded by an inquiry by the High Court and will be in accordance with the judgment of the High Court if it is for misbehavior. There is no basis for the apprehension expressed by the Tamil Nadu Public Service Commission. It must be noted here that State Public Service Commission is a subject specified in entry 41 of the state list. Amendment of clauses 1 and 3 of Article 317 in the manner suggested by us will bring the constitutional provisions bearing on the subject into full accord with the existing distribution of legislative powers in relation to this matter.